IIPA. I'm moving a bit fast because Badam sir shall be waiting for
to give his presentation. Manoj, it's not visible.
मेरी presentation visible नहीं है आपको?
No.
Not yet. Not yet.
आप सेल्फी ले रहे हो, आप ही देख पा रहे हो.
सर मैं दोबारा करता हूँ. चंदन जी मेरे को जरा होस्ट करना, मैं शेयर स्क्रीन कर नहीं पा रहा. सर एक मिनट, वो एक्चुअली आई एम नॉट इन ऑफिस टुडे, तो माय ऑफिस इज ऑर्गेनाइजिंग एवरीथिंग.
ये आपको होस्ट बना दिया, मैसेज आ गया स्क्रीन पर.
ओके.
वैसे भी आपको कौन नहीं जानता मनोज जी, आपको सब जानते हैं.
सर वो मेरे से ज्यादा मेरी वो क्या कहते हैं पीपीटी को देखेंगे ना. चंदन मेरे को होस्ट बनाओ, आप बना दिया आपने?
बना दिया.
ओके सर. Is screen visible now?
Yes.
Yes.
Yeah. Sorry for the little bit of interruption, but when we are handling everything ourselves, it happens. Okay. I move to my presentation. This is brief about our IIPA. We formed it 4.5 years ago, and okay, as a matter of tradition, we always take what are the latest developments and issues for the IP, which happened in our last meeting, and after that in this meeting. As far as latest developments are concerned, I have noted on one change, one section 94R. What happened was that the existing section 194R was introduced in 2022, the Finance Act. This section provides that 10% TDS on the value of benefits or purchases provided shall be deducted by the giver. It resulted in how we are concerned in IBC with section 194R. In case of haircut, whatever benefit was coming to the CD or otherwise also, in that case, the beneficiary like bankers, financial institutions, or otherwise were supposed to deduct a 10% TDS. We made a representation to the government that intention of the section is not to deduct TDS in these cases. It was something else. It was for where the payments were made without treating them as their income in the other hands. And now the government has come out with a circular, and they have clarified that this TDS shall not be deductible by the financial institutions. But there is a, I just show you the circular. Yeah, this is a circular. This circular has come on 30th of September 2022. In this circular, briefly, they have said, in the case of benefit given by the financial institutions like banks and others, banks, cooperative societies, and others, which has been defined therein, if they give any benefit to the CD, then in that case, no TDS will be deducted. But now question arises that in case of, because in our IBC, we have a lot of haircuts, not only for the financial creditors, but many times for the personal creditors also. And in financial creditors, we include other than banks also. But for them, there has been no relaxation given, meaning thereby that the provision of Section 194 will be applicable to them until unless a new clarification comes from the government. Till the as far as present clarification which has come out there, it only gives assumption to the banks and financial institutions. NCLT Chandigarh, has come out with the one circular whereby this is a circular. This is nothing much. They have simply said, they have simply said something therein whereby they said that in case RP requires any extraction of the work, then he can use these specified agencies. Nothing much important is there, but I thought of sharing with my northern region friends so that they can use those agencies, and circular is very much there that you can take care later on. Okay, now I come to the best part of my presentation, latest judgment. In this particular latest judgment, I come across one, recently a very good judgment, which has yet to be reported, but it will be reported. In this particular judgment, Section 138 stay has been granted to the personal guarantor by Punjab and Haryana High Court in the case of Vijay Kumar Gai versus Pritpal Singh Babbar. This is a very lengthy judgment. I just share it with you. This is a 38-page judgment. What basically this judgment is there, I just explained it. As far as Section 138 proceedings under Negotiable Act 1881 is concerned, these are the criminal proceedings. And our understanding of law is that the IBC provides relief only for the civil proceedings. As far as criminal proceedings are concerned, no relief is being provided. But in this particular case, Punjab and Haryana High Court has provided relief to the directors of the CD. And the brief facts, but since it is very, very important case and may be repeated by the other high courts also in the days to come, I'm just giving you the brief of this particular case. In this case, a personal debt was due, and proceedings under Section 138 of the Negotiable Instrument Act were going on in the Jalandhar Judicial Magistrate Court, Jalandhar, vide an order dated 28th May 2020, which allowed the application of 138, and whosoever has filed this particular application, he was asked to proceed against that particular defaulter. However, Honorable Mr. Justice Amol Ratan Singh allowed the appeal on the interpretation of Supreme Court judgment in the case of Swiss Ribbon, Lalit Kumar Jain, P. Maharaja, and other similar judgment that they stopped the proceedings with that particular director on the ground that it was their interpretation. How they interpreted it? They interpreted it based on these three laws which I have just told you: Swiss Ribbon, Lalit Kumar Jain, and R. Maharaja. They said that IBC exceeds the act, all other acts. And why it exceeds, they have gone in depth for this particular reasoning there. They said that in the case of IBC, all assets are with RP. It was basically, I must tell you, this was a Section 94 application, and all the assets are, or jo debt tha, this particular debt was not pertaining to the CD. This was his personal debt. Let distinction be made there also, because to understand the law. Therein they said that all assets are with RP, and debtor has no control. And if he has no control, how he can pay? Secondly, they come out with the logic that IBC exceeds law and shall take care of all the debts, including debts which are not owned by them, including debts which are not part of the CD. And in that case, they can take a better decision how to repay, instead of we issuing a notice and some sort of a negative order against the particular person for a particular debt. Just hold on, please. Anji. ओहो, मैं आप ऑफिस से बात करो, चंदन से, वो लॉग आउट करेगा आपको. Okay, then Based on this particular logic, that IBC exceeds all the laws, and when the RP has been appointed, he will take care of all the debts. They granted a stay against Section 138 in this particular landmark judgment, and Mr. Alok Jagga was a learned advocate who fought this case, and this is, I thought, a very important case. Maybe other high courts do take note of this particular judgment, and then we can proceed further. Now let me move to the second judgment. Ashok Kripalani versus IBBI. This is a, the WhatsApp group में कल काफी ये चर्चा में था. इस केस में, in this particular case, DC order has been, stay has been granted by the Delhi High Court, based on the logic that board has not taken cognizance of all the submissions made by him. And I hope IBBI, just say IBBI, in case of any DC case held by them, they give notice of it in their website. As far as stays are concerned, we expect that in the days to come, they will also notify this there. But this is also a very good judgment as far as those people are concerned against whom disciplinary proceeding has been started or orders has been passed. I think earlier, I remember Gujarat High Court also, Punjab and Haryana High Court also has also passed the similar order. My third case I have taken into account is of Vidarbha Industries Power Limited, whereby a review petition, we discussed this case in the last meeting also. Mukhija ji enlightened us briefly about it. Against it, a review petition has been filed for the for the interpretation of section 7 subsection 5 subsection A and section 9 subsection 5 subsection 1, and this matter has been listed at a very early stage as on 19th of September. And I don't know if we all are aware of the Vidarbha Industries Power Limited case, where it has been held that in case of a difficulty by the CD, the proceedings against him, CRIP proceedings can't be started against him. Let's see what happens after this. My fourth case is, this is NCLT has condoned delay of 197 days in filing of an appeal. I thought of sharing with my colleagues also. If you have any delay there, be ready to pay this small cost and get admitted your petition there. But I remember that in the case of Supreme Court, in the similar situation, the Honorable Supreme Court declined to admit the petition for IBC cases. Fifth case I have chosen is a judgment has come out from the Hyderabad IIT, whereby they have again repeated that during CRIP proceedings, no income tax appeal can be decided. Sixth judgment I have taken is of that of NCLT Mumbai, whereby they have held that financial debt can't be claimed without proof of disbursement. I'm not reading in detail all these judgments, because if I start reading it, I've been allotted only 50 minutes time and already 20 minutes are there. Then it will take a lot of time, and we are here to listen to Madan sir about the interpretation of those particular fees related circulars. Mere company winding up order not absolved from proceedings under section 198 of the negotiable instrument acts. ये जो मैंने 138 का पहले कहा, ये उसके opposite में है. The judgment is very much will be there. I just showed to you, and which you can see later on.
This 138 is, Manojji, a very landmark judgment in case it has been stayed. I think it is a landmark judgment. Yeah.
It is a landmark judgment, and this is the first judgment by any court, and it has been given by the Punjab and Haryana High Court, and that is why I thought of sharing it with everybody. Please, this is another judgment. This is not very important judgment. In this case, they have held this thing. I'm moving on to my next judgment. Bidder can't request for conversion into the sale as a going concern after accepting corporate debtor in slum sale. Actually, basically what happened in this particular case, bidder took over the, as a resident applicant, took over the company CD, and later on, because of some taxation benefit, he asked for converting this purchase into slum sale, which Honorable Court declined. NCLT New Delhi, in the case of Bajaj Rubber Company Private Limited versus Saraswati Timber Private Limited, declined to revive petition as settlement agreement was not adhered by the CD. Why I have chosen this judgment is that in our CRIP proceeding, many a times settlement under Section 12A is being done. When this particular is done, I have seen in my practical cases also that debtors do agree with the creditor that they will pay in the subsequent period. This is this much money, or they whatever amount they agree, they go for the installment of that particular amount, and later on they don't honor those installments. NCLT New Delhi has held in this case that if anybody does not honor his honor his commitment later on, then no remedy lies with us. You have to either move to the Supreme Court, to the civil court. As far as IBC is concerned, it can't give you any remedy. So I have chosen this judgment to share with you only for the purpose, so that whenever we have a settlement sort of things, we should be overcautious and do it with due diligence, and try to see that the debtors have the money to pay. I have chosen my last judgment is, this is also this judgment I have also chosen. This is with reference to ICICI Bank versus Opto Circuits India Limited. In order to initiate prosecution under Section 70 of the IBC, the complainant has to be filed by the IBBI or central government or person authorized by the central government. NCLT has held in this particular case, meaning thereby that at least we got some relief that no prosecution by Tom and Harry can be initiated against us. It has to be done by the statutory authorities as specified in the code, and those statutory authorities are either IBBI or central government or a person authorized by the central government. This is all I want to share with you. I've been allotted 15 minutes. Within that, I've been able to, able to justify those 15 minutes. Now, the topic of the day is, देखिए, we learn a lot. इसमें क्या लिखा है? कुछ में लिखा, if we go, in a plain reading with it, that RP will get a fees of 1 lakh rupees, which will extend up to as specified with the claim that this much amount and all the things. But when we shall look at this with the eyes of Mr. Madan, you will realize that how many things are hidden in it, or how this particular circular has been drafted. And, along with that, they have given the one IBBI press release also. Along with that, they have come out with another amendment also, whereby in the first schedule, clause 26, they have amended there. What that in broadly mean, I'm not going to discuss with it. And, one small circular is also there by the IBBI, whereby they said that all the pending matters be reported to the Honorable, all the pending matters, Honorable Supreme Court and High Court be reported to them also, and made them as a party. For all these three or four circulars, Madan sir will enlighten us. And now with this, I hand over my my mic to Madan sir. Madan sir, welcome.
Thank you, Manojji.
Thank you, Manojji. First, I'd like to say something about Madan sir.
Yeah.
Before he delivers something.
We also wanted to, from the NCLT Kolkata Bar Association, we also wanted to.
Yes, please.
From Madan ji. So Mr. S.M. Gupta, the president of NCLT Kolkata Bar Association, is with us, and he specifically mentioned that he'll be also very keen to welcome the audience and Mr. Madan. So if it is okay, we can also request him to say a few words.
We welcome S.M. Gupta ji, and in fact, we are honored that he has joined us. Thank you very much for giving us honor. Anuradha ji, please carry on.
इससे पहले गुप्ता जी कुछ बोले, मेरा गुप्ता जी को प्रणाम.
नमस्ते मनान जी, नमस्ते.
नमस्कार सर.
बहुत बहुत नमस्ते आपको. और मनोज जी का मैंने अभी सुना, इतना बढ़िया लगा प्रेजेंटेशन. और मदान जी तो अभी बोलेंगे ही, रीजन स्पीकर हैं. तो कोलकाता एनसीएलटी कोलकाता बार एसोसिएशन की तरफ से आप लोगों का, दोनों का, और जो दोनों मॉडरेटर हैं उनका सबका हम स्वागत करते हैं. और सबसे ज्यादा धन्यवाद ममता का है कि वो इतनी तकलीफ करके हर हफ्ता एक प्रोग्राम रिलीजियसली करती है फॉर द बेनिफिट ऑफ ऑल कंसर्न. सो ममता बिरानी deserves a lot of thanks from the fraternity, and welcome you all once again. Thank you very much. Madan ji, please proceed. Thank you very much. Namaste.
Good afternoon, everyone. Thank you, Manoj ji, Mamta ji, and Gupta ji. It has been a great pleasure to be a part of this endeavor, which brings out latest in IBC. As we all know that IBC is a nascent code and maturing and changing every day. So according to the need of the time, so we are gathered here to discuss these amendments and developments. Our learned speaker will speak on the topic of today, which is discussion on amendments to CIRP and IP regulation concerning IP fees. And he is none other than GP Madan साहब. मैंने पिछली बार भी कहा था कि ये जो सर है इनके बारे में मतलब सूरज को रोशनी दिखाने के बराबर है. हम इनके बारे में ज्यादा कुछ नहीं कह सकते. Such a knowledgeable person, reading between the lines. हम लोग पढ़ते हैं तो लगता है कि ठीक है पढ़ लिया समझ आ गया, लेकिन जब इन लोगों के सेमिनार्स हम अटेंड करते हैं तो उसके बाद हमें लगता है कि अच्छा इसका ये एस्पेक्ट भी था जो हमें समझ नहीं आया था. मतलब व्हाट कैन वी से अबाउट देम, कि ये लोग तब से पढ़ा रहे हैं जब से हम लोग एस्पायर कर रहे थे आईपी बनना. नाउ आई विल कम अबाउट अ फ्यू लाइंस अबाउट जीपी मदान साहब. He is the managing partner of Madan Law Office, Advocates and Solicitors. He is a registered insolvency professional, Vice President, Insolvency Practitioners Bar Association, Chairman, NCLT and IBC Committee, PhD, Chambers of Commerce and Industries, Joint Secretary General, NCLT Bar Association. And he is a World Bank IBBI trainer. GP Madan is also an alumnus of Shri Ram College of Commerce, Delhi University, and he has a vast experience of 37 years. He is member of various bodies and he has been a chairman of ICSI Northern Region in 2005. He has written various articles on different subjects.
I think this should come to the topic.
Okay. This is just a short profile, and as Mr. Madan sir says, we would like to invite him to speak about the topic, which is very interesting.
Thank you, Anuradha ji, and sorry for cutting you short. And my sincere gratitude and thanks to my dear friend Mamta Binani. ममता जी की ममता बनी रहती है हमेशा हमारे ऊपर. गुप्ता जी बहुत बहुत धन्यवाद आपका. और गुप्ता जी ने कहा कि ममता जी हफ्ते में एक प्रोग्राम करती रहती हैं. हफ्ते में एक प्रोग्राम तो वो कलकत्ता बार का करती हैं, उसके अलावा डेली उनका कोई ना कोई प्रोग्राम रहता है. वो कहीं ना कहीं स्पीकर रहती हैं ऑन एवरीडे बेसिस. वन ऑफ द मोस्ट वांटेड प्रोफेशनल स्पीकर इन द कंट्री. कमिंग टू मनोज जी जो अभी शुरू के 10-15 मिनट लगाए ना, गागर में सागर भर दिया. All the latest development, including the judicial pronouncement, he has shared with us, and I think उन्होंने तो food for thought दे दिया that after this webinar now I am going to read these judgments. Actually, to be very frank, in the meantime, I've already asked my staff to go through this judgment under 138 and give me a brief immediately.
सर जब गुरु तारीफ करता है तो बहुत अच्छा लगता है. थैंक यू वेरी मच. थैंक यू. इसके लिए वी रेगुलरली गो ऑन पुटिंग आवर लेबर एंड कनेक्टिंग विद द पीपल हु कैन गिव अस ऑल दिस लेटेस्ट जजमेंट्स.
Some of the comments on your initial 10-15 minutes presentation. IBB, Delhi High Court order, interim stay order of yesterday against one of the IPs, one of the most renowned IPs, Mr. Ashok Kripalani, who happens to be an advocate also. Actually, this his case has been argued by none other than Ms. Anjali Sharma, who also happens to be an insolvency professional. So we are really proud of that. And according to me, IPs के matter can be represented by IPs in a better way. This is what my understanding is. An advocate who also happens to be an IP can represent the case of an IP before the judicial forum in a better way. Secondly, Manoj ji, you discussed one case of IIT appeal. I don't know who has gone into appeal in that case, whether the department has gone into appeal or the SSC has gone into appeal. अगर उसकी citation में मिल जाए आपकी तरफ से, that will be really helpful to all of us. अब धीरे से
सर भाई मेरी सब केस की citations हैं तो मैं अपने
चैट बॉक्स में दे देंगे तो बेटर रहेगा.
ठीक है सर.
Thirdly, you discuss a case of NCLT Delhi bench, I think bench 2, where you have said that in case of settlement, if settlement has failed, if the earlier withdrawal was on the basis of the settlement, later on settlement failed, and now the NCLT has not allowed to revive the original case, because according to them, there is no default on the basis of the settlement. That case does not lie within the parameters of insolvency and bankruptcy code. Recently, I also got a similar judgment order from the court in case of Go Air. I was representing Go Air. And there was some settlement, and settlement could not materialize as per the original petitioner. And then they filed an application for revival of the original Section 9 application. And I again represented Go Air, but NCLT did not allow that if there is any default in terms of the settlement, then certainly the revival application cannot lie under Section 9 of the code. So we have to take care that whenever there is any withdrawal on the basis of settlement, even though it is mentioned in the settlement agreement that if settlement fails, a revival application shall be preferred, the courts are not going to entertain that revival application. So whenever we are going to have any settlement, we should ensure that each and every penny is paid in advance. There's no post-dated payment or post-dated checks. If post-dated checks bounce, then certainly NCLT is not going to give you another opportunity. These are my
Mr. Madan.
Yes, Nilesh.
Yeah, Nilesh, please carry on. I would like you to add something there, please.
Mr. Madan, this particular judgment in the matter of Bajaj Rubber Company, which has been given by Honorable NCLT New Delhi, I am having two judgments of NCLT, and wherein it has been very clearly held by the Honorable NCLT. They say that in case any settlement arrangement fails, then in that case, the affected party, which is operational creditor, is entitled to initiate this action. And these two judgments are, I think, bring it to your notice. One is ICICI Bank Limited versus Popto Circuits India, and it is a judgment which has been issued by them on 28th of April. I think we need to consider that also. And then they have referred to another judgment of theirs, which is in the case of Vivek Bansal versus Bruda Drug India Private Limited. So I think the judgment which has been, or the view of Honorable NCLT, I think both the matters are issued by bench 2, wherein they say that once settlement is made, then you are not entitled to, you cannot be treated as an operational creditor. I think two contrary NCLT judgments are there. I think all of us as professionals and lawyers, I think we should consider that, and then based on the same, I think we have to see what is to be done. I think in this particular case also, Bajaj Rubber also, I am sure that appeal will be filed before Honorable NCLT. So because it came to my notice, I thought that let me bring it to the notice of the audience.
I agree with you, Nileshji. In the past, we have got number of applications revived wherever the settlement failed. But my experience of you are absolutely right. There are a number of orders from NCLT, NCLAT also, as you have quoted, just 2 orders from NCLAT. But my experience of last 2-3 months is that NCLT is not allowing these revival applications. Are there any directions from somebody, or they are not taking note of NCLT orders, or there may be some internal meeting between NCLT and NCLAT, and there are some internal guidelines, but NCLT is not allowing. It's not only bench 2 only, but other benches are also not allowing these revival applications.
Right.
If any appeal is preferred before NCLAT, and now NCLAT comes out with some other judgment, or it repeats its own judgment of April or March, as you said, and then they allow revival, that we have to see that. But recent NCLT orders are not allowing the revival application.
Definitely. Yes. Right, Madanji.
Right. Okay. Now I come to straightway to these amendment regulations. And Manoj ji, aapne program as fix kar diya on the amendment regulations. And today again, 3 new amendment regulations have come. CIRP amendment regulations and voluntary liquidation amendment regulations or liquidation amendment regulations. आई थिंक आपके नेक्स्ट वेबिनार की भी तैयारी हो गई है। और आज जो रेगुलेशन जो आई हैं, अमेंडमेंट रेगुलेशंस आई हैं, द स्वीपिंग अमेंडमेंट्स आर देयर. To be very frank, an hour back, I have already given my comments on one of the particular regulations, regulation 36C, which is talking about marketing of the assets of the corporate debtor. I have already given my comments to the media, and tomorrow morning they may be there in the newspaper also. Both many sweeping changes are there, and next time whenever you are going to hold a webinar on these amendment regulations, please ensure you are going to have 2 to 2.5 hours at least for this. So number of sweeping amendments are there. No doubt these amendments are based on the discussion paper on which we already had webinars.
Sir, I should take care. और मेरे सर चैट बॉक्स में जो सॉफ्ट लिंक है सब केसेस के शेयर कर दिए हैं, तो दिस इज फॉर एवरीबॉडी.
We will surely do this. Yeah, thank you.
Okay, now I come to this amendment, second amendment, third amendment. Yeah, is it visible on screen?
Yes, sir.
Okay. This is IBBI CIRP regulations, amendment regulation, third amendment regulation 2022. I think आज जो आई होंगी वो fourth होंगी. Should be fourth only. Let me check it. Yeah, आज जो regulations are, they are fourth amendment regulations. So now we are discussing the third one, which is concerning the IRP and RP fees. Okay. First of all, the title of this particular amendment is this 34B. Fee to be paid to interim resolution professional and resolution professional. This is a new regulation which is being inserted after regulation 34A. Actually, you know, existing regulation 33 is dealing with the fee to be paid to the interim resolution professional, and regulation 34 is dealing with IRP cost, which includes fee to be paid to resolution professional. And the 34A, which is already there, let me go through 34A also. 34A deals with disclosure of costs. Now, after 34A, 34B is being added, and it reads like this. The fee of IRP or RP under regulation 33 and 34 shall be decided by the applicant or committee in accordance with this regulation. First of all, they have made it clear that fee of IRP or RP under regulation 33 and 34. But I think they should have written respectively. That word is missing from here. Because 34 is applicable in case of IRP. So in that case, it is the question of who is going to fix the fee, the applicant. And 34 is dealing with fee of RP. There, the committee of creditors has to fix up the fee, but in accordance with the following. The crux of this regulation 34B is that what is going to be the minimum fee to be paid to the IRP or RP. To begin with, we'll deal with this. Then it says, sub-regulation 2, the fee of the interim resolution professional or resolution professional appointed. Now, this is very important word. The fee of the IRP or the RP appointed on or after 1st October 2022. So if any IRP or RP is going to be appointed after 1st October 2022, the fee shall not be less than the fee specified in clause 1 for the period. Now, this is also important. We'll come to this also. For the period specified in clause 2 of schedule 2. So any IRP if going to be appointed after 1st October 2022, which means it is applicable to all those applications under section 7, 9 or 10 which are pending for admission before adjudicating authority. It is applicable to all those cases also, because there the IRP is going to be appointed. In all those applications which are pending, the IRP has not been appointed so far. The IRP shall be appointed from the date of admission of the application. But इसमें अब एक problem आएगी. Suppose a section 9 application has been filed. This is pending for admission before the court, before NCLT, and no name has been proposed. Adjudicating authority shall be appointing the IRP, but whether adjudicating authority will be fixing up the fee, or this fee now shall be fixed up by the applicant or the COC, no clarity is there on this issue. Because in case of section 7 and 10, the names have been proposed, we know who is the applicant. Applicant has to negotiate with the proposed IRP. But in section 9 application, in 90% of the cases, the name of the IRP is not proposed. Adjudicating authority shall be appointed the IRP, shall be appointing the IRP. But who is going to fix up this minimum fee in such cases? Will it be again the applicant or the COC? I think the jurisprudence is yet to develop, because this is going to be effective after 1st of October 2022. Secondly, it says the fee for the IRP or the RP appointed. So IRP case is clear whether the application is pending or application is yet to be filed. It has to be fixed up by the applicant in case of fresh application. Now, in case where IRP has already appointed, CIRP has already commenced, but now IRP is to be appointed. So as per the provisions, the RP is to be, if the IRP is continuing as RP, then COC is appointing the RP. But if IRP is not appointed as RP, some other IP is appointed as RP, in that scenario, COC proposes the name and appointment is done by the adjudicating authority. So in all these cases, so Radhaji kehegi, now we are trying to read between the lines or somewhere else. In all these cases, we have to take care of who is going to fix the fee and what is the meaning of this term appointed on or after. Even though in case where the same IRP is going to be appointed as RP, if this resolution is passed by the COC of appointment, then COC has to fix up the fee of the RP in terms of this proposed regulation 34B to be read with the schedule. I hope I'm clear. Right. Now, this regulation says the fee of the IRP or RP shall not be less than the fee specified in clause 1 for the period specified in clause 2 of schedule 2. Now, I think I should come straight away to the schedule 2. Yes, here is schedule 2. I think Manoj ji kahin se disturbance aa rahi hai. I think kisi ka mic on hai. Somebody with the name M. अगर आप म्यूट कर दें इनको तो
मैं सबको म्यूट कर देता हूं. आप भी हो जाएंगे तो फिर आप अपने आप को अनम्यूट कर लेना प्लीज.
ठीक है. Right, thank you. Yeah, it says schedule 2 under regulation 34B, which has just been inserted. It says minimum fixed fee. Read the word minimum fixed fee. The word fixed has also been added. It's not only minimum, but it is a fixed. minimum fixed fee as per table 1 below shall be paid to the interim resolution professional or the resolution professional for the period mentioned in clause 2. We'll come to the clause 2 also. Here it is period for minimum fixed fee. It says minimum fixed fee structure. Then it says quantum of claims admitted. If you remember, when the discussion paper came, the discussion paper was talking about, I don't know whether the claim, I think it was assets, if I remember correctly. But now they are talking about quantum of claims admitted. The minimum fixed fee shall be on the basis of the quantum of claims admitted. And this fee shall be, minimum fixed fee shall be paid to the IRP. Now this means at the time of filing of the application under section 7 or 9 or 10 as the case may be, whatever negotiations take place between the applicant and the proposed IRP, it has to be mentioned there that minimum fixed fee shall be, or the fee shall be as the minimum on the basis of the claims which shall be admitted by this IRP. Or we can say rupees so and so as negotiated between both the parties, or an amount of rupees so and so based on the claims admitted, whichever is higher. सपोज मिनिमम आपने 1 लाख फिक्स कर दिया और क्लेम अमाउंट 100 करोड़ के हो गए तो मिनिमम फी उसकी 2 करोड़ रुपए हो जाएगी. तो इन दैट सिनेरियो इट्स और इट विल बी 1 करोड़ or 2 crores, whichever is higher. And suppose the minimum fee is, now minimum fee in such no case can be less than 1 lakh. Suppose you fix 1.5 lakh and the claims amount are more than 500 crores, then the minimum fee shall be 3 crores. So at the time of negotiation, you will write 1.5 crore, or in terms of this schedule, on the basis of the quantum of claims admitted, whatever shall be the minimum fee, out of these two, whichever is higher. So we need to take care of this at the time of initial negotiation, at the time of before filing the application, while giving our consent. Then it further says, quantums of claims admitted. It's not quantums of claim filed. Quantums of claims admitted, and here the claims admitted is not restricted to financial claims. It includes financial claims, operational claims, statutory dues, other claims. All the claims put together, the aggregate of that you have to see. अब यहाँ पे मेरी एक apprehension जो है, that some claims which are not required to be admitted, maybe because of this minimum fee slab, the IRP may admit those claims also. My humble request to all of you, please, that should not happen. Claim admission, collation, reconciliation, the basis should remain the same, which we have been following for last 5 years. That should not change. Greed should not come there just to take the minimum fixed fee, because now the schedule is applicable to us. This is my humble request. There may be a possibility that sometime there may be a borderline case. So the claims original, as per the assessment, it is 490 crores. But so लगता अगर मैंने 15 करोड़ रुपए और एक्सेप्ट कर लिया तो 505 करोड़ हो जाएगा. 505 करते ही मेरी फीस 2 लाख से 3 लाख रुपए हो जाएगी. That should not happen. इसका मतलब ये नहीं मैं कोई लीड दे रहा हूं आपको. Please don't take it as a lead. It's an advice only, it's a suggestion only, a request only. I'm not giving you any lead that you can do like this. Don't read between the lines here, please. Okay. Then it says minimum fixed fee on the basis of quantums of the claims admitted less than or equal to 50 crores. It is 1 lakh per month. More than 50 crores and up to 500 crores, 2 lakhs per month. More than 500 crores up to 2500 crores, 3 lakhs per month. More than 2500 crores up to 10,000 crores, 4 lakhs per month. And more than 10,000 crores, 5 lakhs per month. This is minimum fixed fee. This does not include the fee which you might be sharing with other professionals, because now the sharing has also been barred now. I'll come to that. Now, what is that period for which this fee is going to be fixed? That has also been clarified. पहले बहुत हमारा झगड़ा रहता था कि कब तक मिलेगी, कौन से पीरियड के लिए मिलेगी, बट अभी भी कुछ ग्रे एरियाज हैं. आई एम गोइंग टू डिस्कस दोस ग्रे एरियाज आल्सो. फर्स्ट ऑफ ऑल लेट्स रीड दिस clause 2, period for minimum fixed fee. This minimum fixed fee of 1 lakh to 5 lakhs as the case may be shall be applicable for the period. Which period? From appointment as IRP or RP. So that is the commencement date. Date of appointment of IRP or date of appointment as RP. Till the time of submission of application for approval of resolution plan under section 30 or submission of application to liquidate the corporate debtor under section 33 or submission of application for withdrawal under section 12A or order for closure of corporate insolvency resolution process, whichever is earlier. In any of these 4 cases, filing of application for approval of resolution plan, filing of application for liquidation of the CD, or filing of application for withdrawal under 12A, or if there is any order for the adjudicating authority or appellate authority, this order can be from any of these 2 for closure of corporate insolvency resolution process. In any of these 4 cases, this minimum fixed fee is applicable. Now, I need one clarity. What will happen in case there is a stay by the appellate authority? Stay may be on the admission order. Stay may be on CIRP process. Stay may be on constitution of COC. Stay may be on holding of any COC meeting. Because we see these 4 or 5 different types of stay orders from appellate authority. In all such cases, if CIRP process has come to a halt, whether for this period also this minimum fixed fee shall be payable or not, if you ask me as an advocate and as an insolvency professional also, I will say yes, this minimum fixed fee shall be payable. But on these issues, again, I think the application shall be filed because the regulations are not providing any clarity on this. This clarity should also have been provided. And actually, in my suggestion, when we gave the suggestion on the discussion paper, I gave this suggestion to IBBI from PhD Chamber of Commerce that clarity should be provided in such cases. Another, what will happen from the, okay, I think they are providing a clarity on this also. I'll come to that later on. Let me go through these regulations, then I'll come to that further, my issues on this regulation. Okay, this D actually covers wherever the admission order has been quashed. Normally it is quashed by the appellate authority or by apex court. Whenever any appeal is preferred to the Supreme Court, and Supreme Court in number of cases have quashed the CIRP process. So as per this regulation, from the date of appointment till the quashing, for every month this minimum fixed fee shall be paid. But I wanted a clarity, what shall happen to the stay period in between? According to me, as I said, this is payable. Then it comes to performance link. I'll come to that later on. Let me come to this only. Yeah. Let's go through these three now. After the expiry of the period mentioned in clause 2, ये 4 instances देखे हमने जो, इसमें let's forget about this D, order of closure. Or rather, I'll say, let's come to A, B, and C. Yes, you have filed an application for approval of resolution plan. You have filed application for liquidation, and you have filed application for withdrawal. Now, from this date till the consideration of this application and passing of the order on these applications. Normally, we see आजकल तो as far as A and B are concerned, 2 साल लग जाते हैं. From the date of filing of the application till the date of passing of the order. इस पीरियड में क्या होगा? इस पीरियड की clarity has been provided here in number 3. After the expiry of the period mentioned in clause 2 of schedule 2, the fee of the IRP or RP shall be as decided by the applicant or committee as the case may be. Now, इस पीरियड में फिक्स फी नहीं मिलेगी आपको. ये बहुत बड़ा ग्रे एरिया था. क्लैरिटी प्रोवाइड कर दी गई है, but clarity is going to act against the interest of insolvency professional, I tell you. Because COC is not going to give the same fees now. अगर आपको 5 लाख रुपया, 4 लाख रुपया, 3 लाख रुपया मिल रहे हैं, and if you think the COC will continue with the same fee for this period from the date of filing of the application till the date of passing of the order on this application by the adjudicating authority, I'm having my own doubts whether COC will continue with the same fee. At this time now, again, a window has opened for negotiation between the COC and the RP, which is not in the right spirit. This window should not have opened. And now suppose there is no agreement between the RP and the COC. Do you think the IRP can resign at this stage? Answer is no. On this basis, the RP cannot resign. Because you are not seeking a fresh consent from the RP. And if you don't agree, then section 27 will come into place and COC may decide to replace the RP. That is also not intent of the code or intent of the regulations. According to me, the same fee should continue. Do you think during this period that the RP is not going to remain the trustee of the assets of the corporate debtor? Do you think if the company is the corporate debtor is a going concern, whether RP is not duty bound to keep the company as a going concern? Do you think that during this period the RP is not required to take care of the interest of all the stakeholders of the corporate debtor? Do you think if the company is a listed company, the RP will not continue with the listing requirements? Whether RP will not continue with the labor law requirements? Whether the RP shall not comply with all the provisions of IBC and the regulations made thereunder? Will he not be submitting all his returns and forms to IBBI? Will he not continue to defend the cases which have been filed against the corporate debtor? Will he not continue to pursue with all those cases which he has filed against various parties during CIRP process? He will continue with all these cases. Then why the negotiation of fee at this stage? This is what my issue is. And I would like, I don't think that I should continue with this as it is. I think whatever point I'm raising, I think we should have a discussion on all these issues, Manojji.
Yeah, Anuradha ji and Deepika ji, you please take care of it.
Yes, definitely. I fully agree with you, sir. It actually needs a lot of discussion, especially where the companies are operational. I mean, as you rightly said that the guards will be there, the security will have to be taken care of, the compliances will have to be taken care of. And in case the company is a going concern, then there's a lot of work. So it is not possible that the RP can go without a considerable amount of fee, to, enough to cover up the work that is being done. So maybe we can have some observations or questions.
We need to send representation. We need to send representation to IBBI that the same minimum fixed fee should continue in this period also. Or what? Same fixed fee or whatever fee has been decided. Either same fixed fee or the fee decided should continue. There's no room for any negotiation at this stage.
No, I agree with you, sir. In fact, I think we can do it in a organized manner rather, since we have this organization IIPA. Maybe Manoj can enlighten us on that.
Yeah, ma'am.
There is a hand raised by IP Prashant ji. He's also asking about this thing only. Can I invite him to ask his question? Regarding this, Prashant ji.
Yes, sir. Thank you. I have one query with Mr. Madan, that in the regulation 34B, clause 1 and 3, 1 and 2 both are saying that fees of IRP or RP under regulation 33 and 34 shall be decided by the applicant or committee. So by the applicant or committee in accordance with this regulation. But regulation 33 clause 4 says that the amount of expenses ratified by the committee shall be treated as insolvency resolution process cost. And insolvency resolution process cost includes fees of IRP and RP also. So what if applicant decide X amount and committee ratifies Y amount? Then how this regulation 33 clause 4 is going to be in consonance with the regulation 34B, that applicant decides to pay higher amount and committee fix only to the minimum level, then what will happen?
Okay.
Question number 1. And question
let me respond to this.
Yes, sir, please.
34B talks about minimum fixed fee. If any fee is more than this, then certainly 33(4) comes into picture. But when you are reading both the regulation 33 and 34B, 33, 34 and 34B, at that point of time, you have to have harmonious construction of both the regulations. Minimum shall be as per 34B, final. Anything over and above, 33 and 34 come into picture.
But sir,
that is why 34B says any fee fixed under 33 and 34 shall be subject to this regulation, shall be subject to this schedule. The minimum as per 34B, rest as per 33 and 34.
So in any case, it will be prerogative of the COC only to ratify the expenses, but it should not be the minimum fees.
Yes, over and above minimum ratification by COC.
Even suppose applicant
and I tell you, Prashant ji, I think if you talk about ratification, the COC fee, the RP's fees is not going to ratification each and every time. Once it is fixed, that's okay. It's not going for ratification. Yes. All other CIRP expenses are going for ratification in every COC meeting, but the COC RPC is not going to ratification in every COC meeting. That is once for all is fixed.
But sir, applicant decides for higher fees, and then COC denies for that.
Minimum shall be paid. Then in that, in that scenario, I am very clear. Suppose I am going to be IRP. I am going to negotiate with or going to fix a fee with applicant. Applicant says minimum 5 lakhs. As per regulation, minimum 2 lakhs. Now this goes to COC. COC says, sorry, we will give 2 lakhs. So my commitment, my binding, my negotiation, my agreement with the applicant should be such the rest 3 lakhs shall be paid by him. That should be part of the understanding. If the COC does not ratify this fees, the remaining portion shall be borne by the applicant.
Okay, nice, sir. Next, kindly throw some light.
इसकी फीस दे देना मुझे प्रशांत.
Yes, पक्का दूंगा सर. एक बार एक्स्ट्रा मिलने दीजिए.
प्रशांत जी, हमारे साथ आप शेयर जरूर करना, कुछ आपको ऐसा एप्लीकेंट मिले जो सीओसी से ऊपर फीस देने को तैयार हो. Actually, we should feel very happy about that.
In all the cases, कभी कभी ऐसा होता है कि एप्लीकेंट तो तैयार हो जाता है 2 लाख रुपए 1.5 लाख रुपए IRP की फीस देने को, सीओसी तो 1 लाख भी नहीं दे पाती है.
मनोज जी, अभी हम उस पे आएंगे रेगुलेशंस में बड़ी 5-5 करोड़ रुपए की बातें हुई है.
यस सर, मेरा एक सबमिशन हो रहा है आपसे, एक इस पे और लाइट थ्रो कीजिए कि जो क्लेम्स एडमिटेड at one stage and thereafter if there is a change in the claim amount, because within 90 days claims will be changed, and even after that, क्योंकि रेगुलेशन जो अभी नया रेगुलेशन आया है उसमें तो यह आया है कि हम क्रेडिटर्स को ये लिखेंगे कि कितना उनको कौन कौन पेंडिंग है अमाउंट और उनको क्लेम के लिए इनवाइट करेंगे. So is there any chance of change in the fees once fixed after change of the amount of claim?
There is every chance of whenever the resolution is passed by the COC for fixing of this minimum fixed fee or IRP or RP as the case may be, it should be part of the resolution that tomorrow, if there is any change in the total claim amount and if because of that change, the minimum fixed amount, minimum fixed fee, there may be change in the minimum fixed fee also, the COC will have to consider and the minimum fixed fee shall be paid as per the revised claims.
Thank you, sir.
सर, आपका एक छोटा सा इशू आ रहा था जो कृपलानी साहब सर से पहले, whereby you said कि in case of the balance period, basically period when we put up the application for resolution applicant, what I feel and what we have seen practically doing it there also, that for to reach that particular stage, RP or COC has worked together for a year or more than a year. For that, they do develop confidence in each other. All fees and other related issues do happen initially. In that case, when they develop confidence in each other, most probably this matter that how much fees will be paid by the COC, which will be agreeable to the RP also, I think the practically maybe get settled without much hassles.
I tend to differ. Sorry, yes, sir.
I also differ on this.
I tend to differ कि 1 साल 2 साल प्लान पेंडिंग है AA में और 5 लाख रुपए महीने की फीस देनी उस टाइम पे पड़ी खड़ती है, बट RP is doing the work. So इसका क्या वे आउट है और उस टाइम पे क्या लास्ट जब मीटिंग होगी ये रेटिफाई किया जाएगा कि इतनी ये रहनी चाहिए, मतलब till the plan is approved by the adjudicating authority.
Whenever the plan is approved by the committee of creditors and the RP is authorized by the committee of creditors to file an application before the adjudicating authority for approval of the resolution plan, at that point itself the resolution shall be passed that what shall be the fees of the resolution professional for this period, which is commencing from the date for the period commencing from the date of the application till the disposal of this application. But by no means, according to me, in my view, the fee should remain the same which was there during CIRP period. Negotiation means bringing down the fee. It cannot go up. Let's be practical.
I agree with you, sir, but I also agree with Manoj ji where he says that the confidence is developed between both the parties by then. And of course, it also depends upon the level of operations in that company. In case there is a good level of operation and there are troubles, then I'm sure the COC will consider it. But having said that, I believe that, putting it across to IBBI as a representation may be a good idea to ensure that some minimum amount, some reasonable amount is given to the the RP to ensure that.
Yes. Why not the same fee which is there during CIRP?
Yes, even I agree with Madanji. Why not the same fee? Why reasonable amount?
If we can negotiate this aspect with anyone, either the COC or the IBBI, I think it will be a wonderful thing.
Nilesh ji, please carry on.
Yeah, Mr. Madan, as we know that during the CIRP period, the fee which is paid to us is for two kinds of responsibilities. One is that we run the CIRP process, and second is for maintaining the going concern status of the company. And when CIRP process is over, so then they will not be paying us for running this CIRP process. So then our responsibility will be to maintain the going concern status. And in most of the cases, we have seen that business are not running. So what we have to do is that we have to deploy security, though responsibility is still there. That security has to be there. You have to keep a watch. And then whatever legal formalities are required, legal compliances are required during this period, filing of income tax return, filing of other returns, and everything that is to be done. And then at the same time, we have to follow up with we have to make a representation before NCLT for the purpose of getting the plan approved. A number of applications are filed where you have to give your replies, you have to brief the lawyers and all that. So I think the fee cannot be the same during the first period when CIRP's process is also being run. I think fees should be there. No doubt fee should be there, but it should be lesser than the fee which is payable for the period during the CIRP. That is my view.
I agree with you, sir. In the view of reasonableness, maybe this is what we can say. Yes.
As far as reasonableness word is concerned, it is very dangerous. Merely for an IP, it can be something reasonable. For COC, it can't be something unreasonable. In that case, that is why I had said that if we have a confidence in each other, COC has a confidence in the RP, then this reasonable is good for both of them. And sir, if let's say something, go for a hypothetical assumption that if something does not happen or does not materialize, तो सर मदान सर आप हो ना, हम आपके पास आएंगे, फिर आप उसका बताओगे कि कैसे as an IP हम फीस लें.
मनोज जी, मेरा एक कहना है, suppose
yes sir, please.
As per this regulation, your minimum fixed fee is 2 lakhs per month. As per decision taken by CIRP, your actual fees is 4 lakhs per month. Now you have filed an application for approval of the resolution plan. Now this particular regulation 34B says even there is no surety of this minimum fixed fee.
Yes,
at this stage, now the negotiation will happen between the COC and the RP that what shall be the fee for this remaining period. There is no guarantee of the minimum fixed fee also. Please consider that. मुझे कोई फर्क नहीं पड़ता क्योंकि I have not taken up any assignment. If IPs are agreeable, then we are ready for this. This amendment is acceptable to us. I don't mind this. I have given my suggestion. According to me, the same fee should continue if you ask me personally.
Even I feel कि same fees should continue क्योंकि बहुत सारे cases pop up हो जाते हैं. There are n number of things, uncertain things which can pop up.
और नीलेश जी, बिल्कुल नीलेश जी, मैं एक बात और कहूँ, आप भी खुद लॉयर, मेरी वाली स्थिति में ही हो आप भी. आप ये देखिए, ड्यूरिंग द CIRP योर कंसंट्रेशन इज ऑन रेजोल्यूशन प्रोसेस, बट बाय द टाइम द रेजोल्यूशन प्रोसेस इज कमिंग टू एन एंड, इतना लिटिगेशन खुल जाता है, यू आर गोइंग टू बी इन्वॉल्वड देयर.
Correct.
You deserve more fee than the CIRP process period fees.
Actually, yes, in some matter, definitely. In some matter, definitely. In yes. number of litigations are there, and RP has to devote too much of time briefing the lawyers, attending the meetings, and doing a number of things. So
and just a minute. No, not only this. Then complaints against you before IBBI, yes. Before NCLT, before police, before CBI, copy to Prime Minister Office, copy to MC, and so and so. You are yes. subject to so many complaints. Your mental peace is gone. Your family life is gone. Aap sochiye jara. And now you will not be paid even minimum fixed fee.
I think there is one way, sir. There is maybe one way. I mean, maybe we can deliberate that in the beginning, this kind of demarcation can be made, or rather, while the fee is being fixed at the time of taking, the voting on the fee, that this much particular amount of fee will be for the CIRP process, and this much particular amount of fee will be for the entire other things comprising of, in case the operations are there, what will be the quantum of fee, or in case the guards are there, or in case, I would say the location is a very notorious place and the security calls for a lot of work. So depending upon the quantum of work and depending upon the quantum of complications involved, maybe in the beginning, some kind of arrangement can be reached out. Well, once again, nothing to say about this confidence developing between the two parties, like Manoj has brought about, I think that's the best thing that can be, worked out on. So based on all these things, maybe something in the beginning can be worked out. Maybe Madan sir can enlighten on this kind of thing.
I think, sir. Madan sir, I'm sorry, I'm interrupting. Let's move forward. We are already 4:15. We go with your suggestion that we should make a representation to the IBBI that minimum fees should be paid to us. Number one. Number
provided our members agree to that, because here the house is divided. We need to have consensus on this.
We can discuss it internally and then we can move for it also. But I still hold my opinion very much that whatever assignments I have done, initially there used to be a lot of hassles. Ye hai, wo hai, aise hai. But when we start working together, it's not easy to run a company. I remember when I was running my MR case, which was having a 40,000 crore rupees of debt there, and 8 or 9 projects were running there. A lot of confidence was required to run all those projects. And we develop confidence in each other, and hopefully we'll be able to root through it also. And as far as consensus is concerned, I think we can devote another 4 or 5 minutes on it and then move to further topic, please.
Manoj,
also there is this question. Also there is one question from the in the chat box about the IP fees, which requires maybe Madan sir can.
I'll not touch that aspect unless we have the IP's clarification.
Yes.
And there is one suggestion, that time period for appointment till approval, not submission of the plan.
Time period for appointment till approval.
Approval of the plan by the AA.
I couldn't get it. Time period for appointment till approval.
Time period of the fees.
Yes. That's what I'm saying. I'm saying
this is what you are saying.
I'm saying the same thing.
Yes.
I'm saying the same thing.
Yeah.
मदान साहब, ये जो फीस रिवाइज होगी क्लेम रिवाइज होने पर, वो रेट्रोस्पेक्टिव होगी या प्रोस्पेक्टिव होगी?
Good question. According to it should be prospective. Suppose today you have 100 crores, your fees are fixed accordingly. After 3 months, your claims are 500 crores. So your fees shall be fixed 500 crores के हिसाब से, but for prospective effect. Not with that.
I also agree with you. Absolutely agree.
Okay. Now, should I come to this regulation again now? Let me start the screen. Okay. So this period of minimum fee we have discussed. Okay, now I'm coming to this sub-regulation 3 again. 34B2 provision. Provided that, here it is. Provided that the applicant or the committee may decide to fix higher amount of fee for the reasons to be recorded. Now for this purpose, the reasons are to be recorded. Taking into consideration market factors such as size and scale of business, operations of corporate debtor, business sector in which corporate debtor operates, level of operating economic activity of corporate debtor, and complexity related to process. So for the higher fees is concerned, they have given you liberty and the reasons to be recorded on the basis, they have given the examples only according to me, take into consideration, this is not the final list according to me. There may be other considerations also, which we were just discussing. So higher fee may be fixed on the basis of it, the reasons are to be recorded in writing, that's all. Now I come to sub-regulation 4. For the resolution plan approved by the committee on or after 1st October 2022. Now, plans approved by the committee, not by adjudicating authority. It means the plans which have already been submitted and to the COC and the pending for its consideration, all those plans now must consider this. What? For the resolution plan approved by the COC on or after 1st October 2022, the committee may decide in its discretion. But here a word is, the committee may decide, not shall decide. It's up to the discretion of the committee to pay performance-linked incentive fee not exceeding 5 crores of rupees. ये होने वाला नहीं है. पढ़ के खुश बहुत होंगे हम, ये होने वाला नहीं है. I'm not just sounding negative, but I'm just giving you the practicality. Maybe exceptions may be there. अभी एक केस भी आया था डिसिप्लिनरी मैटर का, where I think 3 or 4 crores has been given as incentive. And but only warning has been given, no action has been taken. It has been found to be in order by disciplinary committee. And why it has been found to be order? Because this particular amendment regulation was in pipeline. It was in pipeline, and the Honorable Disciplinary Committee, the whole time member, knew it that this is in pipeline. That is why only a small warning has been issued. It has not been held to be invalid or illegal or unlawful. So not exceeding 5 crores of rupees in accordance with clause 3 and clause 4. I'll come to that also. Clause 3 and clause 4 mein kya kya hai of schedule 2. Or may extend any other performance links incentive structure as it deems necessary. So what is there now? COC has got two discretions. Discretion number 1, to pay performance linked incentive fee, which cannot be more than 5 crores of rupees, or may extend any other performance linked incentive, no limit. This may be in addition to this 5 crore, this incentive fee, though the word uses or means any of these two. But sometimes Supreme Court says or may be read as and also. Like they say may can be read as shall and shall can be read as may. Though word uses or, either you pay the incentive fee not exceeding 5 crores or may extend any other performance linked incentive structure as it deems necessary. And in this case, according to me, the plain reading of the regulation says no limit of 5 crores there.
Sir, just a question for the benefit of the viewers. This performance linked, is this also minimum fixed, or is it something again a discretion?
It is discretionary, so there cannot be minimum fixed here. It is discretionary on the part of the COC. So once it is the moment we say minimum fix is become mandatory, it's absolutely discretionary. However, higher limit has been prescribed, that is 5 CR. But again, in case of performance incentive structure, higher limit is not there. This is what my reading is.
So this is the word used is may.
May, yes, that's what I'm saying. The word used is may. Now, what sort of these two incentives are there? Now let's come to this. In schedule, table 1, 3 and 4. First of all, performance links incentive fee for timely resolution. So if you are able to file this application for approval of the resolution plan within 165 days, then RP may be paid 1% as realizable value. This incentive of 1% of realizable value. अब यहां मेरी समस्या है. What do we mean by realizable value? ये realizable value तो we used to read in liquidation regulations, or maybe in the liquidation, or maybe in the valuation report. In valuation report, we have the fair value, market value, liquidation value. What is this realizable value? Are we talking about the resolution plan amount? Actually, the clarity should have been provided. What is this realizable value? अब उन्होंने एक illustration दी है. उस illustration में there are more confusions. उन्होंने कहा हम आपको बताते हैं इसको कैसे कैलकुलेट करना है. Here is the illustration. It says a corporate debtor having liquidation value of 20 crores rupees was resolved. Means a resolution plan has come. Liquidation value is 20 crores. A plan has come and the realizable value to creditors was 100 crores rupees. Now, what is the meaning of this term realizable value to creditors was 100 crores rupees? Simply, are we paying that in the resolution plan, there is a provision for payment of 100 crores of rupees to creditors? Does it mean that? It means if that is so, then it means it does not include CIRP cost. For that purpose, payment of CIRP cost, which is part of the resolution plan, shall not be considered. Number two, I take an example of a real estate project where 1,000 crores of claims are there of resolution, the allottees. And the resolution applicant says, I will consider all these 1,000 crore on at face value. जो भी उनकी booking है, उन सबको उनकी booking मिलेगी. In addition to that, I will infuse 50 crores of rupees. So now the total plan value is 1,050 crores or 50 crores. But the creditors are getting their 1,000 crores now. All those allottees are getting 1,000 crores. And the liquidation value may be 500 crores. There may be a possibility. So for this additional 500 crores or 550 crores, whether the incentive shall be paid. I think better wording should have been used in the regulation, considering the real estate projects also. I come to this again now. Yes. If the plan is submitted, resolution plan approval application is submitted to the adjudicating authority within 165 days, it is 1% of the realizable value, 165 days to 270 days, 0.75%. Beyond 330 days, nothing. And more than 270 days or up to 330 days, 0.5% of the realizable value. This amount can be paid to the resolution professional as performance-linked incentive fee. But it is a discretionary. And then they are talking about another incentive. Manoj ji, please dekhiye, somebody is unmute. Then there is performance-linked incentive fee for value maximization. This is also performance incentive fee. Earlier one was for the period, now for the amount. Here they say the performance-linked incentive fee for value maximization may be paid to the RP at the rate of 1% of the amount by which the realizable value is higher than the liquidation value. जिसको उन्होंने एग्जाम्पल दिया कि अगर 20 करोड़ रुपए की लिक्विडेशन वैल्यू और 100 करोड़ रुपए की रियलाइजेबल वैल्यू है तो ऑन दी 80 करोड़ he shall get this 1%. And then they are combining it with the application to be filed in such and such days. So both the things have to be put together, that what is the realizable value and in how many days you are filing the application before the adjudicating authority. So this performance linked incentive is based on these two things. But I would like to have discussion on this. What is the meaning of the term realizable value, particularly in a real estate project? I would like the views of the members, but including Mr. Nilesh Sharma. Nilesh ji, are you there or he has left? Nilesh is there.
Yes. So I think I totally agree with you. The term realizable value is totally different. So actually they could have used the term resolution value or resolution amount, because realizable value or liquidation value, as you know, that when we get the assets valued, we ask the valuers to give us liquidation value or fair value, and in case of liquidation we ask them to give us a realizable value, which is an estimate. And here what they are talking about is, I think, the amount which actually the resolution applicant is paying under a resolution plan. So I think the term,
just a minute, is paying or is infusing?
No, paying. Infusion is different, boss.
मैं बताता हूँ आपसे. नहीं, I come to this. मैं वो real estate वाला project लीजिए.
हाँ जी.
Where the 1,000 crores of claims are there.
Correct.
And he said, I'll meet the entire liability. सबको जो इनका 1,000 crore आया होगा, 1,000 crore वालों का ऐसे क्योंकि उसके पास इन्वेंट्री पड़ी है बहुत. वो कहता सबको प्लॉट्स मिलेंगे आपको. तो इसके लिए उसे कुछ करने की जरूरत नहीं है कुछ भी.
Correct.
Maybe
So-
90%, maybe 90%, 95% completion per project.
Okay.
Claim is filed for the 100%.
Yes.
In such a scenario, whether RP is entitled to this incentive.
Okay, I will give share my view. Actually, as you know that if suppose there is a real estate project, then we are asking the resolution applicants to offer in their resolution plan. They have to tell us how much money they will be giving to the creditors. Suppose some financial creditors are there other than home buyers. Then to home buyers, how much, whether they will be handing over the project. And then for the purpose of doing that, they have to bring in some money. And that money can be, if suppose a project is worth or liabilities are suppose 1,000 crore, for example, and he brings in only 100 crore. So that 100 crore also ultimately after completion of the project, he has to take that out, because he is not coming here only for the purpose of completion of this project. He is coming here, 100 crore he is bringing as working capital for the purpose of completing the project and all. Okay, so this is not to be linked with 100 crore. Okay, so if suppose in a real estate project of this kind, there can be one resolution applicant who says that what I do is that I will complete the projects, I will complete the project, but I will ask the people, home buyers, to contribute additional amount of rupees, suppose 500 per square feet. So he is asking them to pay more, but there can be one RA who says that I don't want anything from you. Okay, so I will be infusing some money, which every RA has to infuse. And by using that money, I will complete everything. I don't want you to pay anything for. So that means the liability of these home buyers is being repaid in kind. Okay, suppose 1,000 crore is the claim. So we is repaying them 1,000 crore rupees, and 100 crore can never be the basis for this. Even in any other case, suppose there is an industry, and in the value of that industry is 500 crore. He is taking that responsibility that I will be paying 500 crore, but it is not that he will be bringing in total 500 crore. He may bring in 100 crore rupees, out of which he will pay upfront 50 crore or 75 crore. Rest of the money he may utilize for the purpose of working capital, and then out of generation or out of even sale proceeds of surplus assets, he can repay. So I don't think it has to be linked with the money which he will be infusing. It has to be linked with the total money which is being offered to the creditors and every stakeholder in a resolution plan.
Make example leta hu, suppose in a real estate project, the liquidation value of the real estate project is 700 crores. Claims filed are for 1,000 crores.
Correct.
Now the resolution applicant is coming forward with a plan, and he says that the project is about to be completed. I will infuse 100 crores for the remaining work, and all the flats shall be delivered to their respective allottees. And uska incentive kya hai? Kyunki wahan pe 300 crore ki unsold inventory padi hui hai. That is his incentive. Now 700 crores is the liquidation value. 1,000 crores are claims. 100 crores he is infusing to deliver the project, to deliver the houses, the flats to the allottees. So what is the realizable value in this case?
I think it should be, because he is offering to hand over. He is not asking for any additional amount.
Yes, yes.
So the 1,000 crore is the liability, and he is taking that liability on his head. And he says that by using the assets, which is the incomplete structure, so he is taking that responsibility that by infusing working capital, I will complete this project and I will hand over the flats to the creditors whose liability to the company is 1,000 crores. I think 1,000 crores should be the basis. But at the same time, when COC is approving, when COC says that I will give you incentive, so COC will consider that out of 1,000 crore, he is saying that I will deliver to you, but he is not completing this entire 1,000 crore thing. He is bringing in 100 crore, and then with that 100 crore, he is completing it. So they will consider that aspect, and based on the same only, they will decide how much incentive should be given to him. If suppose
in such a scenario in Form H, what do you write is the resolution plan amount?
Resolution plan amount,
in the same case which I'm saying, what is the resolution plan amount?
Okay, actually, what I do normally is, in this type of a case, I don't say that the 100% of the admitted claim is being repaid. So normally what I say is that the liquidation value, I treat that as the value.
My question is, what is the planned amount?
Okay, so then
Very
in
simple
that case,
question.
no, it is very simple. I think it is very interesting thing that especially in case of a real estate company.
Yeah.
So I have been, because I was not having any answer to this question as to what should be the value, because they are not getting the money in kind.
Yes.
So I have treated liquidation value as the value which is being offered to them. So in that case, our RP will not get any incentive.
I think that is what I'm saying. The clarity should be provided, and this realizable value word should not be used here. मनोज जी, second suggestion हमारी तरफ से जाना चाहिए.
बिल्कुल.
पांडे जी ने उमरनाथ पांडे जी ने लिख दिया 100 crores is the realizable value. उसके ऊपर incentive मिलना चाहिए in that scenario.
Okay. And then here, Mr. Madan, they are fixing up a cap. What is the need for fixing up a cap? I think the problem before us was that RPs were not being paid adequate amount of the fee. Secured creditors, they can take care of their interest. The cap should be fixed up. It is for them. COC mainly consisting of the bankers and financial institution. If they say that we will pay you incentive of rupees 10 crore, then why should IBBI say that no, incentive should be only 5 crore?
Do you think bankers will pay 5 crores also as incentive?
No, I'm not saying that, but I'm saying is that there is no need for putting up a cap. But I think what is going to happen is that most of the bankers, they will say that IBBI has decided these fee scales, so we will pay you that much only. So even in bigger cases, I think then solution will be that they will say that, okay, we will pay you some incentive. So some part of the fee.
But Nilesh, if you read the second part, जहाँ पे और लिखा हुआ है, वहाँ पे cover हो जाता है ना, it's or.
किसमें second part?
Yeah, read this 4 on your screen.
For the resolution plan approved by the committee on or after 1st October 2012, the committee may decide in its discretion to pay performance-linked incentive not exceeding 5 crore rupees in accordance with clause 3 and clause 4 of schedule 2. Now, नहीं, बस यहाँ अभी पहले यहाँ तक पढ़ते हैं.
यहाँ तक तो ठीक है.
आ रहा हूँ मैं उससे आगे भी. तो इसमें
आपके क्वेश्चन का जवाब आगे है.
मैं बताता हूँ. I think नहीं हुआ है. देखिए, तो इसमें वो कह रहे हैं नॉट एक्सीडिंग 5 करोड़ इन अकॉर्डेंस विद क्लॉज 3 एंड क्लॉज 4. और क्लॉज 3 और क्लॉज 4 में वो क्या कर रहे हैं, वो उनका इंसेंटिव स्ट्रक्चर बता रहे हैं. देन दे से और may extend any other performance linked incentive structure as it deemed necessary. तो वो कह रहे हैं जो क्लॉज 3 एंड क्लॉज 4 में जो इंसेंटिव स्ट्रक्चर है, यू कैन हैव ए डिफरेंट इंसेंटिव स्ट्रक्चर, बट दिस कैप स्टिल रिमेन्स अकॉर्डिंग टू मी. Or means you either you follow clause 3 and clause 4, which is the structure there, but 5 crore I think remains. So this clarity I think will be required.
I agree with you, but I will read to the my benefit. अगर मुझे 5 वर्ष ऊपर भी करना होगा, provided if there is any case.
Okay. But I think इसमें clarity रहे तो थोड़ा सा क्योंकि we are having different interpretations.
Yes,
so that means scope for different interpretation is there. So that should be plugged.
Okay. So now only one paragraph remains here. Where from this amount can be paid? Sub-regulation 5 says the fee under this regulation may be paid from the funds available with the corporate debtor, contributed by the applicant or members of the COC, or raised by way of interim finance, and shall be included in the insolvency resolution process cost. I think there is no debate, there is no discussion required on this. This is very plain and simple. They have simply clarified where from the sources can be there. With this, I think we come to end of this particular regulation. बाकियों में दोनों चीजें जो है मनोज जी, within 5 minutes each it can be covered. So within next 10 minutes we can conclude it. If you, yeah.
Mr. Midan,
yes, please.
I think for me the issue here is that our problem is that we are not getting paid. Though fee can be decided, but ultimately I cannot raise the interim finance without the approval of COC. Okay, so my problem in most of the cases, and especially in real estate matters, the problem is that you are acting as RP, but you are not getting any fee, and even even you don't get the money for the purpose of meeting your cost, the fee which is to be paid to the auditor, which is to be paid to the valuers and other service providers. I think for that here that nothing is there. I think they must have covered it under the COC's code of conduct for COC, huh? But I think had there been something which is mandating the COC to, I think, make some arrangement and that regularly the fee of the RP is paid, I think that would have been better.
I gave my, as I said, when I gave my suggestions to IBBA chairperson, I wrote very clearly that the regulation must provide what shall be the minimum fee, who will pay the fee, and at what point of time this fee should be paid. All these three things should be clarified, but here they have come out with only who will pay and what shall be the minimum fee, at what point of time it should be paid is not been clarified. I think recently we have seen one disciplinary matter also, because there are a number of judgments, number of orders from the Honorable Adjudicating Authority, that if COC does not contribute, then certainly you may even take a decision not to include them in the COC. Even such harsh orders have been there. But till date, I don't think that IBB has come forward that who will contribute and at what point of time it should be contributed. So this payment of remuneration to IRP or RP and payment of other CIRP cost is still a question to be discussed and deliberated. No clarity has been provided.
Correct, correct.
We have two hands raised. In fact, three hands raised. One is Mr. Shiv Nandan Sharma, one is Mr. Ravi Chandran. Maybe we can,
Yes,
we can take one by one. Maybe Mr. Ravi Chandran. You can come up with your question. Please unmute yourself.
Good evening. I hope I'm audible. See that the explanation what they have given is for the purpose of realizable value is that for the purpose of class 3 and 4, the realizable value means the amount payable to creditors in the resolution plan approved under section 31.
Actually, Mr. Ravichandran, that illustration which has been given for the purposes of calculation of the incentive, not for the purpose of clarification of the realizable value. If you read this illustration, that's for the purpose of calculation of the incentive. Okay,
probably that wording is not there, but then the realizable value, what I feel is that, sir, this submission is that creditors in class is not covered actually. Creditors in class, like home buyers is not covered, because what happens, sir, some of the, see, when you take over the assets of the company, in our case also, what happened, the company had a lot of current assets also, like cement or steel or whatever is there that it has taken. And it has taken that balance receivables also. Everything was with the resolution applicant. So with that, he could complete the project and then give back to them. So here the creditors, actually here the word also I have seen that the word says creditors, including central government and state government or local authority to whom a debt in respect of payment of dues. This is not the debt in payment of dues is not coming for home buyers. So it is mainly for the, they are excluding the CIRP cost. They are excluding the, this one, employee cost. Employee cost is excluded. CIRP class is excluded. Any payment to, anything to home buyers, creditors in class is excluded. Otherwise, whatever you are paying to operation creditor or financial creditor or government are included and then computed. That's my submission.
But again, this is a disputed question. Operational creditors shall be paid in terms of section 53. Dissenting financial creditors shall be paid in terms of 53. Those payments shall be made by the resolution applicant later on. Who is going to be the dissenting financial creditor? All those things cannot be decided at this stage according to me. I think that we need to send a representation to IBBA for providing clarification on this realizable value. Sure. Yes.
There is another question. If there is stay in constitution of COC by Honorable NCLAT, appointment of IRP is done by NCLT. If CIRP is dismissed, who will pay the fees and expense of IRP?
I think I've already raised this question.
Yes.
When you say what is going to happen, already taken care. Yeah, we need to, IBS needs to provide clarity on this.
Sir, regarding, sir, I have one question. Regarding the period when there is a stay by the ANCLAD or any of the authority, so how the period would be calculated? This 180 days, 270 days, 330 days? Because if there is a stay of 1 year or 365 days, so should we exclude those period? Exclusion application has been filed and
Yes.
we have got the
Answer is
exclusion
yes.
application.
Answer is yes. This litigation period has to be excluded.
But 330 days.
But इसका meaning ये नहीं होना चाहिए for this exclusion period you will not get the remuneration.
No, but 330 days is inclusive of the litigation period of 60 days. So,
my dear, please read Rainbow Papers. Supreme Court says all the timelines under the code are directory in nature. Latest judgment from Honorable Supreme Court.
प्रॉब्लम क्या है सर, हम समझ गए, आपने समझा दिया, बट सीओसी तो वो नेगोशिएट करके कुछ देने वाला नहीं।
आप नहीं, वो सेपरेट इश्यू। देखो मैं अभी आप टाइमलाइंस की बात कर रहे हैं, मैं टाइमलाइंस की बात कर रहा हूं।
I totally understand.
Sir, we move to the next topic, please. Time is running.
I think Ms. Shivnandan Sharma wants to say something. Please unmute yourself.
I want to clarify one point, that the recently disposed show cause notice on the percentage of fees has been silent on the percentage because they have said that we have not yet addressed this show cause because the matter is sub judice with the apex court. So the 4 days ago, that Jash order is pretty clear and the sword still remains there because there are many issues in that.
Mr.
How
Nandan,
that settled.
as I told you, when this order was pronounced by IBBI knew it very well that they are coming out with this amended regulations.
There are other issues, the way the incentive was finalized.
So that is why they are not taking that's why they are not any action, and they have gone very slow and liberal in that.
Yes, sir. Now, I want to also suggest one thing, that which I have been talking to the members and the Corporate Affairs Ministry, where you see Institute of Chartered Accountant has come with the guidelines of fees. When you do representation on point 1, there is a fee guideline, and they must, you see, like Nilesh, I agree a bit, but while I am running CIRP process and going concern, I am not paid adequately, Nilesh ji. So you are saying that after the submission of plan, my support goes, but you must understand that my remuneration is not fixed, commensurate to my cost, my fee and structure. And in worst case, Madan Sahab, we can suggest the regulator that at least 90% should be the minimum fees, because at least we have a bargain point, because regulator is in a different mode. So go to the institute guidelines, and they, in such cases, consultancy services is 35,000 rupees per hour. So while you form CIRP 7, you file this form, that form, you spend hours and your fees are justified. So kindly go through, while you are making that representation, the institute settled minimum fees. God bless you.
शिवनंदन जी, इसके बारे में एक बात मैं आपसे करना चाहूंगा। जो इंस्टीट्यूट, तीनों इंस्टीट्यूट्स ने फीस डिटरमाइन करी है, सीए ने भी, सीएमए ने भी और सीएस ने भी। बट चलिए अब आईबीसी के काम की बात नहीं करते, दूसरे काम की बात करते हैं। डू वी कमांड दैट लेवल ऑफ फीस इन आवर अदर वर्क? अगर उन्होंने लिखा होगा कि एक पार्टनरशिप डीड को बनाने के लिए आपको इतने पैसे लेने चाहिए, डू यू नो मार्केट रियलिटीज आर दैट काइंड ऑफ फीस इज बीइंग पेड इवन फॉर द गवर्नमेंट जॉब्स। तो हम उनको बेस लेके यहाँ पे करें तो दैट
सर उसका 50% भी आप अलाउ कर दो तो मिनिमम फीस निकल जाती है।
सर वो दोनों अलग-अलग चीजें हैं।
I had day before yesterday having Madan Sahab come to one court to meet Ashish Makhija, where I was appointed by the adjudicating authority, and we have fought with the authority by saying that we will take zero fees because authorities are not ready to accept so many things. Madan Sahab will discuss those issues separately, and I'm probably going to raise it with somebody in the apex court because I have access to that why such things should happen. When these matters reach you, and you must see the conduct of members, how they are behaving.
So that's why my humble submission is, as far as this period is concerned, the minimum fixed fee should be for the period from the date of commencement of the appointment of IRP or RP till the time the disposal of the application by the adjudicating authority. Matter ends.
At least there should be 90% or 85%.
Bargain negotiation.
We should have same fees, or otherwise at least a minimum benchmark again.
The date of filing of the application should be replaced with the word the date of disposal of the application. That's all. Everything will be resolved.
Nilesh, you want to add something, please?
Acha, no. So I was just clarifying to Mr. Sharma that what I said was that actually the responsibilities during the CIRP period are double. In case of liquidation, in case of after submission of application for approval of resolution plan, I think responsibilities are lesser. But at the same time, as Mr. Madan said, in most of the matters, we are seeing that a lot of litigation is there and a lot of time is spent on those things. So I'm not saying that if you are less, already you are paid the fee, which is not commensurate with your activities or commensurate with your efforts, then it should not be reduced. But if you are being paid adequate amount of fee, which is commensurate with your responsibilities, then in that case, I think there is a case that for a reduction of some fee during the period post filing of application. But at the same time, the facts are different in all the cases. There may be some cases where responsibilities are much more, because in number of applications have been filed before the court, before NCLT. A number of litigations are going on at separate before different courts. So in that case, I think efforts of the RP will be much more. So I did not mean that in all the cases it should be reduced.
And moreover, as far as the regulations are concerned, the discussion point is not on the fees of the which has been paid during CIRP period. The discussion is on minimum fixed fee.
Correct.
And I think suggestion minimum fixed fee should continue till the time of disposal of the application matter ends.
Madan, in near future, the regulation is coming that post filing of approval of plan with adjudicating authority, COC can still be held. And you will find that those COC will be seeking fee reduction, retrospective settled fees also.
बिल्कुल होगा sir, बिल्कुल होगा.
For हम real estate cases में I am already facing. My interim financer has raised issues with me. I am also doing a very tough real estate proposal, and we find that I took an interim finance, and they are already asking me that why IPE, why this, why that. They do not know that there are going to be cross litigations. KV developer has created bigger problem for us on the retrospective real estate cases. Now, so many other that judgment rainbow will have what impact and what plans will be redecided. We really don't know how things are going to shape up.
I agree with you. I agree with you. So in line with that, now coming to this another second amendment regulation, we just discussed third. Now second one is hardly any amendment is there. It's so simple. Actually, the code of conduct, a new clause has been added. It says in the IBC-IP regulation, in IBC-IP regulations. These are not CIRP regulations, sorry. This is IP regulations. And the first schedule is nothing but code of conduct in IP regulations. So after clause 26, clause 26A has been added. And it says an insolvency professional. And here IP ka meaning IP mat lena. IP means IRP or RP as the case may be. IRP, RP or the liquidator as the case may be. And IP shall not accept stroke share any fee or charges from any professional and or support incentive provider, support service provider who are appointed under the processes. ना आप किसी के साथ शेयर करेंगे, ना किसी से लेंगे, ना किसी को देंगे. That's all. Neither you will accept nor you will share.
Does this include IPE? Does this include the IP to which the IPE is related?
IPE को मैं भी touch नहीं कर रहा है, and according to me, the IPE is not part of this. According to me, if you ask me clearly. I'm very clear on that. IPE sharing of fee with IPE is not part of this. I'm waiting for IPE के लिए separate guidelines regulations जो लाने वाले हैं. I'm waiting for those. Actually,
Sir, you-
IPE,
But sir, support service provider में IPE नहीं आता क्या?
But अभी एक चीज बड़ी अच्छी लगी मुझे इसमें, that any fee or charges from any professional and or support service provider. तो उन्होंने ये clear कर दिया that you can have a support service provider. मुझे ये लीड मिल गई है मुझे, whether वो IPE हो या कोई और हो, एक लीड मिल गई that a resolution professional can appoint support service provider.
I agree with you, sir.
COC does not
अगर
COC does
IPE
not
का
approve adequate fees. There should be no embargo in my sharing, my paying him anything. This regulation, I should not be there. I cannot accept is fine, but if I want to, reward a support, why there should be an embargo on me?
No, I don't think आपने किसी को engage किया है, उसको जो fees दे रहे हैं, उसमें जो fee आपके साथ share करें. I don't think that's in the.
Not the question.
No, sir. I have one question. For example, that if new IP comes to picture, he appoints some senior IP as a process advisor with him and says that whatever fees I be getting, I share it with you. No embargo has been put on him.
मैं IPE को बाहर रख रहा हूँ for this discussion.
नहीं सर, मैं IPE की बात नहीं कर रहा. मैं जैसे एक प्रोसेस एडवाइजर की एक इंडस्ट्री है कि जिसके अंदर any new IP comes out to be there, he is not associated with any IPE. Then he appoints any senior IP as a process advisor along with him. Now with this particular clause, that thing is gone away.
Why gone away?
Sir, say he is getting some fees from the CRIP case, say 2 lakh rupees, and he has appointed a process advisor with him that says that we shall share equal fees with each other. So in that, no, he can't do. Can he do right now also?
I suppose RP is getting 2 lakhs rupees per month.
Hanji.
Now he is appointing resolution as service provider, and service provider is being appointed for 1 lakh per month.
Hanji.
तो वो उसकी तो सेपरेट फीस हुई ना 1 लाख रुपए की.
नहीं सर, मैं उसकी सेपरेट फीस की बात नहीं कर
रहा.
अगर
COC अप्रूव नहीं करती तो आरपी कहता मैं अपनी फीस में से तेरे को दे देता हूं.
Yes.
Why there should be an embargo on me?
मैं सर यही कह रहा हूं.
I will clarify why there should be an embargo. Actually, reason is that you are appointed as RP and you are not allowed to delegate your main responsibility. You can take the help of other professionals, but responsibility remains yours. If suppose you are sharing some fee, suppose you are getting a fee of 5 lakh and you say that, okay, I'm taking the help of some other senior RP. So what is happening is that you are not taking decision. You are dependent on some other RP for your decision making. That means what? That you are delegating your authority. So which is not permissible. So, and second thing is that whatever you do, you should do in a transparent manner. If you are taking the help of some outside consultant, then get the approval of COC for his fee. If you are appointing some service provider, so then that service provider, the whatever terms are there, those should be disclosed to the COC. And why should you pay? It should be paid by the company only after getting approval of COC.
मैं मनोज जी का क्वेश्चन डिस्कस करता हूँ इस तरीके से. सपोज आरपी की फीस है 5 लाख रुपए. अब मनोज जी को लगता है कि मैं उतना कॉम्पिटेंट नहीं हूं, मुझे किसी और की सपोर्ट भी चाहिए इसमें. ना मनोज जी कम्स टू मी, मदान जी मुझे आपकी सपोर्ट चाहिए. क्या विल यू प्रोवाइड योर सर्विसेज टू मी, नॉट टू द CD? विल यू बिकम अ हेल्पर, अ सर्विस प्रोवाइडर टू मी एज IP? I agree with them. I'll provide services to Mr. Manoj and I'll charge 1 lakh rupees from you. And if he pays 1 lakh rupees to me, so I remain a service provider to Mr. Manoj Kumar Anand, an insolvency professional, not to the corporate debtor of which he is a resolution professional. I think that is not barred here.
I have a different opinion, Mr. Madan.
It is barred.
I cannot share. So I should be allowed to share with you or.
According to me, it is a service provider to the corporate debtor, not to the insolvency professional.
I agree with Madan ji.
हम जो रखते हैं, हम जो service providers और legal advisors रखते हैं, they are legal advisor, service provider to the corporate debtor, and corporate debtor is being represented through a resolution professional. But
Sir,
here
to add to Madanji's this thing, we have an office staff, we have an employee, we have a chartered accountant employee.
Yes.
So whether we are not including as a professionals, they are my staff.
Yes.
No, but
you have answered
Akaji, I agree with you.
qualification.
देखिए, sir, एक मिनट. Akaji, I agree with you कि आपने अपना staff रखा हुआ है and they are doing it. But what I'm telling you, what practically seen is there that whenever any new IP gets any new assignment, he always look after some senior IP so that he can assist him. Person who is getting first assignment, he is not in a position to do it. In that case, he always come with one of the senior IP and says that you assist me. In that case, will that and at the same time, COC says that we shall pay you the X amount which we have agreed with you. Nothing to be paid to the that senior fellow. Reason for that is that you are responsible for all the things. In that case, is there any embargo? And according to Madan sir, there is no embargo as far as this language is concerned.
There is no embargo. Just a minute. There is no embargo provided, as Nileshji said, you do not delegate your duties and responsibilities to that outsider.
And the fees is paid out of my pocket. It is not to be charged from the CD.
Yes, there is no
embargo. It is not a CIRP cost, it is not embarked.
Sir, in the addition, if we read the regulation clearly, it clearly says that who are appointed under the process.
Yes.
So that it is, you have to see that I cannot take the share of the fees from the professional appointed during the process. But definitely I can pay to anyone who is providing me services. There is no embargo at all.
Absolutely.
There is no confusion in this regard. Let us be very clear, I think.
I am having a totally different opinion on this, except that what Mr. Madan has said, that you should not delegate your responsibility. My point is that when you are appointing a super RP, you are consulting with him. So that means what? You are appointing, the super IP is not having any responsibility under law. When you are appointed as RP, your responsibilities are also there. But if you are taking the guidance of somebody else who is not having any responsibility, but still he is exercising or enjoying the role of RP, if you take the help of some senior RP. So according to me, these are the personal kind of services. Can a doctor, you go to a doctor and you ask him to perform a surgery on you, and that doctor says that no, there is somebody else who will be performing the surgery. So I think that is not acceptable. Here also we are appointed as RP by COC follows a process, and after that they identify us and then they give us a particular assignment. They don't expect us to, I think, take the help of some outsider and for each and everything. If we need some help from some advocate, we need some help from some other RP, I think that should be appointed through a transparent process, and then he should be paid from the company, not from your pocket. He is not supposed to provide you services. You are taking in the services for the company. So I'm having a different opinion, but I think this point is something where people can have different opinions. So, but let's see if there is any clarity by way of some judgment.
कोई डिफरेंस ऑफ ओपिनियन नहीं है नीलेश जी, मेरे हिसाब से सभी जो कह रहे हैं अपनी जगह।
नीलेश जी, हम लोग आपके पास धीर के पास ओपिनियन के लिए किसी टाइम आते रहे हैं। मैं कल मदान साहब के पास भी जा सकता हूँ, एंड ही सेज मैं ओपिनियन के 5 लाख रुपए चार्ज करूंगा, एंड COC अप्रूव्स 2.5। तो आई विल टेल मदान जी कि मदान जी 2.5 लाख अप्रूव हुआ है, 2 लाख मैं आपको दूंगा अपनी जेब से, आप काइंडली सपोर्ट मी बिकॉज this is a critical legal opinion, and you remember that we have been coming for critical legal opinions to you.
I don't think, Mr. Sharma, this should be.
So I will be ready to pay to Mr. Madan because it's a critical opinion. So I should not have any embargo in paying him additional fee because I'm paying from my pocket. I am accepting embargo. I should not take away from you, but I should have right to pay you.
और वैसे भी बड़ा सिंपल है जी, लैंग्वेज बड़ी क्लियर है। हु आर अपॉइंटेड अंडर द प्रोसेसेस, तो एनी प्रोफेशनल हु हैज बीन अपॉइंटेड इन कंसल्टेशन विद द कमिटी ऑफ क्रेडिटर्स फॉर द कॉर्पोरेट डेटर, ओनली दोस प्रोफेशनल्स और सर्विस प्रोवाइडर्स आर कवर्ड हियर। इफ आरपी इज टेकिंग एनी पर्सनल एडवाइस और ओपिनियन और असिस्टेंस फ्रॉम एनीबॉडी एंड ही इज पेइंग फ्रॉम हिज ओन पॉकेट, दे आर नॉट कवर्ड इन दिस रेगुलेशन।
Yeah, and further, Nilesh ji, COC has full right to replace. If COC feels any super IP is taking after and the current IP is not doing his work, He has all right to replace the RP.
No, but we are not disclosing it to the COC. We are seeking consultation from somebody. It is not
So
disclosed.
if we are not disclosing that, there is no question of sharing. So then
So
I
that
don't
is
think
not.
it
So that is not something which can be brought on record. I think you can have something.
Nilesh, I think now let's conclude here. What conclusive comes out to be there. Madan sir, please sum up कर दीजिए, and then we move to another point, please.
नहीं, मैंने अपना पॉइंट बिल्कुल कह दिया. मेरे हिसाब से कोई एम्बिग्विटी नहीं है इसमें. इट्स इफ आरपी इज पेइंग समथिंग टू फ्रॉम इज लाइक अ टीम मेंबर ओनली. तो आपका अगर टीम मेंबर है और टीम मेंबर को एज समबडी सेड मेरे ऑफिस में चार्टर्ड अकाउंटेंट है, कंपनी सेक्रेटरी, मेरे ऑफिस में इन हाउस काउंसिल अवेलेबल है. इफ आई एम पेइंग समथिंग टू देम आउट ऑफ माय ओन फीस, देन नोबडी कैन स्टॉप मी फ्रॉम शेयरिंग दैट फीस. But if I'm appointing somebody for the corporate debtor, and if I'm paying something to him, and then उसे बोल रहा हूँ कि इतने कट मेरी हो जाएगी, 20% मेरी कट, 50% मेरी कट, that is what is barred here.
No, I totally agree with you, Mr. Madan. This particular circular or this particular notification does not talk about the things which we are discussing. It totally the professionals which are appointed under the process. So it is not talking about any other thing except the professionals who are appointed through under the CIRP process. You can't share fee with them. I totally agree with it.
Now coming to this circular, Manoj wanted this circular also to be discussed. This circular says that IPs are advised and IP shall do. एक जगह एडवाइजरी है, एक जगह मैंडेट है. अब वो क्या एडवाइजरी और क्या मैंडेट है वो डिस्कस करता हूं मैं आपसे. नीलेश जी, इसमें आपका भी मैं इनपुट जरूर चाहूंगा.
Sure, Madan.
It starts with the word of late. It has been observed that in a few matters, Honorable Supreme Court and several high courts have considered and delivered judgments wherein stand of Union of India or IBA remained unrepresented because both these institutions were not a party in the concerned proceedings. I fail to understand how a petition or SLP was preferred before High Court or Supreme Court without making Union of India or IBB as a party. मेरे तो गले नहीं उतरता ये पहला सेंटेंस. वो रजिस्ट्री एंटरटेन नहीं करेगी उस रिट को.
Yes.
अब रिट SLP कब जाएगी? Because you are here, you are challenging the virus of the code or the regulations. आगे अगर हम पढ़ते हैं तो वही आ रहा है. अगर आप चैलेंज कर रहे हैं किसी प्रोविजंस को या किसी डिसीजन को, किसी ऑर्डर को, यू हैव टू मेक एमसीए और यूनियन ऑफ इंडिया और आईबीबी एज ए पार्टी. उसके बिना कैसे पॉसिबल है ये? मैंने भी इतने रिट पिटीशंस फाइल की हैं. एमसीए एंड आईबीबी आर इनवेरिएबली पार्टीज देयर.
3 दिन पहले जस्टिस नजीर ने एक ऑर्डर दिया स्टेटस को का, वेयर यूनियन और एनीबडी इज नॉट ए पार्टी.
क्या है वो? उसमें व्हाट वाज
ऑर्डर दिया है अपने. हमने वी डिक्लेयर्ड एडलवाइज एंड आईबीबीआई एंड आईडीबीआई एंड अदर एज रिलेटेड पार्टीज. दे हैव गॉन इनटू अपील एंड जस्टिस नजीर हैज गिवन ए स्टेटस को ऑर्डर विदाउट यूनियन एंड आईबीबीआई बीइंग ए पार्टी देयर.
एक्चुअली शर्मा जी,
और ये रेनबो में भी यूनियन कहां पार्टी थी?
1 minute. Sharma ji, there is a difference actually. When a writ petition is filed or SLP is filed, then Government of India or the concerned department has to be made as a party. But when we are filing an appeal under IBC, then it is not required because that dispute is between two parties. Okay, so if you are challenging the order of NCLAT, I don't think IBBI becomes a party there. No. They will have to file they can file an impediment application, but I don't know whether they will be admitting them as a party. If this type of question of law is there, which affects, I think, the provisions of law, or where some serious issue is there, as we have seen that like interpretation of this particular matter has been there, which has been dealt with in rainbow papers. So I think this type of issues, they want to become party. So that, I think, seems to be the...
Rainbow mein an appeal has been preferred against the order of NCLAT.
Correct.
So why IBB and MCA should be party there?
They should be.
Why should they be party? In case of appeal against the order of NCLAT, IBB cannot be a party.
Cannot be a party, yes.
Filing an appeal. But here you are discussing here that what this paper, the circular is saying, a few matters were before Honorable Supreme Court and High Courts, they have considered and delivered judgments wherein stand of Union of India or IBP remain unrepresented since both of these institutions were not in a party to concerned proceedings. This matter is of great concern as in some of such cases, scheme of the code was in question. So it means you are challenging the virus of the code. Scheme of the code was in question which required to be defended earnestly. While we are trying to retrieve the situation through further legal recourse, our apprehension is, now please read it. Our apprehension is that there could be many more such important matters pending or might arise in future. ये apprehension क्यों है? सबसे पहले यही क्वेश्चन पूछता हूँ, why this apprehension is there?
I think it is arising out of this rainbow paper judgment that they know that.
But this is overreaction. This is overreaction.
Sir, what I feel is that if there is any such sort of thing there, where in any proceedings the IBBI or MCA is not made the party, then court in their wisdom can also say that they should also made a party because it is affecting a lot.
Yeah, बड़ा simply बोल दो ना इसमें all IPs को, if you are in some case as IRP, RP or liquidator, if some appeal has been preferred or some writ petition has been filed, please intimate it to us. That's all. It's so simple. You make the IP responsible to give a submission or give an intimation to IBBI. Then in my case, an appeal has been preferred or a writ petition has been filed. इसको इतना घुमा के कहने की जरूरत क्यों है? अब पढ़िए. Accordingly, insolvency professionals are advised to inform IBBI without any delay about any important issues relating to virus interpretation and applicability of the provisions of the code. Rules and regulations made thereunder are being contested before the High Court and Supreme Court in respect of any assignment handled by them as on date. Now here what they are saying, any assignment handled by them as on date. It's not talking about being handled. So handled according to me includes whether you have handled it or it is being handled by you. It covers both the scenarios. अब मेरे केस में मैंने केस हैंडल की है, आज की डेट में उसमें कुछ हो रहा है, मेरे को पता ही नहीं लगेगा, तो मैं कैसे बताऊंगा? आई थिंक ये सर्कुलर ने एक सिंपल इसी पैराग्राफ में खत्म हो सकता था बस. अकॉर्डिंगली वर्ड हटा के IPs are advised to inform IBBI if any appeal, writ petition, SLP is preferred. In your case, then please intimate it to IBBI, matter ends there only. ये जो भूमिका शिरों में बांधी गई है ना, that is very dangerous.
और दूसरा, सुप्रीम कोर्ट के पास तो जो भी इश्यूज जा रहे हैं वो क्वेश्चंस ऑफ लॉ के बारे में तो हैं, not of facts. So that means in all the appeals going to Supreme Court, we have to inform them.
And you are invariably a party there. Anyway, इसमें खास कुछ नहीं है. हमारे किसी कंपनी में अगर कुछ ऐसा हो रहा है तो एक इंटीमेशन दे दो IBBI को immediately. That's what the crux of the circular.
We have to abide by. Yes.
बस इसमें ज्यादा डिबेट करने की, डिस्कशन करने की जरूरत नहीं है. If any of the cases which we have handled or is being handled, the moment we come to know any appeal or writ petition has been preferred, intimate it to IBBI along with the copies of that application or petition. बात खत्म. If you are having a copy of the same. Isn't it?
ये cases will be confined to IBC only or any other law also?
IBC only. Any. But if the issue involved is relating to IBC, वो तो IBC के लिए.
अभी देखिए ना, अभी पढ़िए. IPs are advised to inform IBBI without any delay about any important issue relating to virus interpretation and applicability of the provisions of the code, rules and regulations made thereunder. It's very clear. And in respect of the assignment, तो कोई ambiguity नहीं है इसमें. कुछ हो रहा है तो intimate कर दो, copy of the petition or the appeal, matter ends.
Correct.
So from my side, that's all. Thank you very much, everybody. 2 घंटे झेला आपने, 2.25 घंटे मुझे.
I'll call upon Mamta ji to give a vote of thanks. Thank you, Madan Sahab.
Wonderful, Mr. Madan. Thank you very much for this.
Thank you.
Mamta ji? I think she's not there. So on behalf of IIPA, I'd like to thank all the speakers and especially Madan Saab and Manoj ji. Thank you so much, and all the patient participants. Thank you so much, sir.
Thank you, Madan sir.
Thank you very much. With this, we are ending our meeting.
Thank you. Thank you.
And Manoj ji, next उसके लिए अब तैयारी कर लो जो आज regulations आई हैं amendment.
Liquidation के बारे में सर.
Liquidation, voluntary liquidation, CIRP तीनों आई हैं आज.
तीनों आई हैं सर. वो 30 सितंबर तक हमारे को छोड़ दो, बिकॉज वो सीए वाला काम भी करना थोड़ा बहुत होता है हमारे को. उसके बाद अक्टूबर के फर्स्ट वीक में रख लेंगे.
रख लेना, तब तक पुराना हो जाएगा. आजकल तो आता ही होड़ लग जाती है वेबिनार्स करने की.
हाँ, होड़. देखिए सर, हमारे वेबिनार्स जनरली हर टॉपिक में सबसे पहले होते हैं, चाहे वो सुप्रीम कोर्ट. देखिए आज भी 4 या 5 वेबिनार हैं और उनमें से मेनली सबके सब वो लोग सुप्रीम कोर्ट की जो हमने केसेस डिस्कस करे थे लास्ट सैटरडे को, उसी के ऊपर कर रहे हैं. तो वी नीड टू मेंटेन दैट लीड. तो हम इसको फिर करते हैं सर. We go with your suggestion.
Thank you,
sir.
There
Thank
is
you.
one very unusual thing that in the review application, the bench has been changed. The original order 19th is not being heard by the original bench. The second judge has recused himself at the order stage itself.
आप रेनबो की बात कर रहे हैं
ना? जो दूसरा केस है 19 को आ रहा है
विदर्भा,
उसमें Jatinder has recused himself at the order stage itself unofficially, and he is not in the review. If you will see reviews with another judge, Indra and another judge.
ओके, चलो आपने एक इंफॉर्मेशन और मैं भी दे देता हूँ. इन केस ऑफ जो PG to CDs के केसेस चल रहे हैं, where many PGs have moved Supreme Court, and in all those cases, majority of the cases stays have been granted. Stay किस चीज का मिला है? That if RP has not filed the report, then he will not file the report. Number 2, if RP has filed the report, that report shall not be acted upon. तो ये स्टे मिला है. Not in all the petitions. अनिल अंबानी की एंड सिंगल्स की, भूषण वाले, उनकी पिटीशंस एडमिट, उनमें स्टे नहीं मिला है.
Madan sahab, I had told you last time.
Just a minute, मैं कंप्लीट कर लूं. अब what has happened, the update in that is that after the stay, then Union of India submitted a letter to Supreme Court of India that all these applications should be clubbed together, all these petitions should be clubbed together and should be heard by a particular bench which refused the stay to Ambani's. So then these matters were listed before that bench, और उस बेंच ने पहले तो 2 हफ्ते का टाइम दिया, लेकिन कल मुझे पता लगा अब ये मैटर shall be heard on 30th of October. Till that date, all these matters are stayed wherever the petitions have been filed. And incidentally and fortunately for personal guarantors, principal bench, उसके सामने अगर कोई भी मैटर आता है ऐसा, प्रिंसिपल बेंच इज एडजर्निंग द मैटर साइने डाई, जब तक सुप्रीम कोर्ट का फैसला नहीं आएगा हम इसको नहीं सुनेंगे. while all other benches are listening to these applications and are passing orders. इसके ऊपर भी मेरा कहना है, मैं made a request also to NCLT president that uniform practices should be followed by all the benches across India.
Madan sahab, if you recollect, I made you a phone call.
Ji.
And the apex court should have specific judges to hear it.
Ji.
Because the way it is going, and because the apex court orders become law, so they should go to particular judges who are good in, because Justice Banerjee's orders are in much difference to Rohinton's order. And you know, the way the things are going, we are talking to the Bar Council, I've talked to the President, I've even talking to DYC, that at least when he is here, he must ensure that IBC should be heard by competent judges who understand the company law and the bankruptcy law.
Sharma, number likhwana. That day I couldn't save your number.
I'll send you a message.
Please, thank you so much.
I have your number.
In any case, from IIPA side also, Nandan, Shiv Nandan Sharma ji, we are really thankful. You have, you know, with your deliberation, you are adding a dimension in our talk. We are from IIPA side also, we are very, very thankful to you.
God bless you. Good luck, sir.
Thank you. Okay, right, everybody.
Okay, Ji.